Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League Season 3, A Glorious Decade, A Century of Service.
Hello and welcome to CNBC TV18, The Thought League Season 3, a platform where business leaders, legal minds, policymakers and global thinkers come together to spark the next wave of transformation. In this episode, we are joined by one of India's most influential legal architects. Cyril Shroff is Managing Partner Cyril Amarchand Mangaldas. Bringing an international perspective from Los Angeles, California, we have John B. Quinn, Executive Chairman and Founding Partner of Quinn, Emanuel, Urquhart and Sullivan LLP, who advises on some of the most complex international disputes. John is a lawyer with a formidable reputation. His recent cases include representing Samsung against Apple, Ukraine against the Russian Federation in commercial, treaty disputes as well as territorial disputes before the European Court of Human Rights. This is where leadership meets foresight. This is the Thought League Season 3. Let's begin. John and Mr. Shroff, thanks both of you for joining us here. It's a pleasure to have you right here on CNBC TV18. Let's sort of map this out to begin with. John, if we can start with you, if you can describe to us, I mean, you have law offices around the world. What are the new age disputes courts across the world are grappling with?
I would say first, everything related to data. Data has been referred to as the new gold. And we're seeing all kinds of disputes, whether it's disputes relating to artificial intelligence, disputes relating to privacy issues, data breach type issues. There's a whole host of issues that the importance of data is throwing up. The second thing I would say is a real growth area is climate change, which is impacting everything from securities law, disclosure by companies, governance, real estate, you name it. Those are two areas that I think globally are really growth areas in disputes, data and climate change.
Okay, Mr. Shroff, data and climate change are the two areas John has described. Would that be your experience as well, right here in India? And if you want to add, any others?
So, of course, these are also very prominent areas of rise of disputes in Indian courts as well. I'd like to add a couple, looking at it from an Indian lens. I think we are also seeing the emergence of a whole new genre of disputes relating to geopolitics or geolegal risk, as it's called. And I would add a kind of an Indian bonus topic as well, which is we are seeing family disputes because the Indian business environment is very strongly founder and promoter driven, and families, as they pass through generations, sometimes there are disputes. Many of them get resolved, but they are significant situations. And we are also seeing almost a whole new generation of governance disputes as well. For example, there's a recent, case in the papers that we read about every day in electric vehicles and cap aggregation. So those are examples of new generation of disputes. But the two big ones are what John said, data and climate.
Absolutely. Let's go one by one. John, if you can sort of detail the first one out, data. I mean, what are the scope of disputes? What exactly are we talking about? And if you can sort of use examples, that'll be great.
Sure. I mean, data is so valuable. I mean, data is the fuel that drives the technology economy. So, for example, we see having large amounts of data as being a feature of market power, of giving large tech companies power because they have access to so much data. And this has gotten the attention of competition authorities, antitrust authorities around the world about how companies develop monopoly power in markets because they have access to so much data which they've collected. Data breach, has become an enormous issue. In the United States in particular, there's a whole plaintiffs bar that has developed legal theories about how and why companies should be liable when there's a data breach. There's experts who are prepared to testify about how it seems like no matter what a company does, there's always something more that they could have done, should have done. And they've kind of come up with theories for damages where data is valuable, so members of a class of individuals who have had their data leaked have a claim equal to the value of their data, or equal to the value of their time and having to monitor the situation and pursue a claim, or theories under breach of contract. You have my data, there was an implied contract that you are going to protect my data, and you obviously breached that contract. So data breach, enormous issue. Privacy has been a big issue in many countries around the world for a long time, certainly in the EU. But it's only, I would say, within the last 5 or 6 years that Americans have gotten sensitive and concerned about privacy, the privacy and use of their data. It's Americans have woken up to the idea that big tech is using their data and monetizing it, and in the past hasn't necessarily had permission to do that. So it's kind of a view that's developed as big tech as big brother, and there's a concern about that. This is played out in the legal sphere, with legislatures have enacted laws in the various states which create private claims and causes of action and damage theories, or maybe liquidated damages, for releases of private information. We still don't have a national law in the US for addressing data, or I'm addressing privacy, but at least half of the 50 states have some type of privacy law. And then I would say another important example is artificial intelligence, which in itself, it raises a lot of new, novel legal issues. Of course, artificial intelligence, large language programs have an enormous, insatiable thirst and need for data. So this data is being hoovered up and used by large language
Models.
AI companies that have LLMs, and used to train their models. And questions are being raised about whether that's appropriate, the use of that data, whether individuals consented to it. So, I mean, those are some examples of the use of data and how it's playing out in the legal sphere.
So there is data monopoly, data breach, privacy, and artificial intelligence. John, you mentioned 4 things. I want to just sort of focus on a data monopoly, especially with regards to big tech. Have the courts kind of laid out, you said there is no sort of national law in that sense, but states draw their sort of legal judgments, etc. On data monopoly? I mean, have courts drawn a line between legitimate data dominance and unlawful data monopolization, John?
I mean, I wouldn't say that per se. It's an indicator of market power. So both in competition law around the world, antitrust law in the US, competition antitrust claim analysis begins with, does the company have market power? Is it a monopolist? And courts have recognized that large amounts of data, possession of large amounts of data, does give market power. It limits the ability for new entrants or others to compete that don't have the same access to large volumes of data. So in a sense, it kind of checks the box of one of the elements for an antitrust or competition claim.
Mr. Shroff, you want to come in with data specifically and the Indian experience? What are we seeing?
It's very similar. And in fact, I think the Indian context is that we have much more data. As a country of 1.4 billion people, I think the context is significantly more enlarged. And we are on the threshold now of acquiring a new law, the Digital Personal Data Protection Act, which is going to create a whole new slew of disputes, regulatory disputes, commercial disputes between parties as well. So this whole topic is going to be significantly magnified. Our view on data as a nation is very similar. Data is the new oil, new gold, whatever you want to call it. And I think there will be a lot of legal rights relating to it which need to be protected. There was a mention about AI. So I think we're starting to see similar litigations emerge here on fair use of data that is being used to train the large language models. There's a famous New York Times case that is pending in the US courts. We have a little bit of a copycat litigation here between ANI and OpenAI, and I think that jurisprudence is emerging in terms of what is the meaning and scope and boundaries of fair use. So we are seeing that. We also saw recently a PIL being filed in the case of DeepSeek, and where various parties have been joined. I think the principle, it's more a geopolitical litigation rather than technology law-related litigation. I think the principle which the court made an observation on was that AI is a dangerous tool, be it in anybody's hands, whether it's American or Chinese. So that's a new kind of angle that is being developing as well. But back to the headline point on digital and data is going to be a massive new topic of disputes.
John, with regards to artificial intelligence, and you talked about large language models, are courts responding kind of fast enough? Businesses are being built, billions of dollars are being invested, and these companies have the data. So what are courts going to decide from here? On what are courts going to come in on, from here?
Yeah, I mean, you referenced the case of New York Times versus OpenAI. That's one of dozens of cases in the US that pose the issue about whether it is copyright infringement to use copyrighted works, whether literary works, as in the case of the New York Times case, or musical works, or visual works, to train large language models. Now, we're talking here about the input. We're not talking about the output. We're talking about the use of copyrighted material in the background to train the large language model. Is that copyright infringement, or is that what's called in the United States fair use, which is not copyright infringement? The issue of the output, whether the output from the model is substantially similar and whether that's copyright infringement, is a much simpler issue that I think is analyzed on traditional copyright principles. That hasn't been so much the focus. These cases are working their way through the courts now. In the OpenAI New York Times case, the New York Times complaint recently survived a motion to dismiss, that is to say, a preliminary motion at the beginning of the case to dismiss the case, arguing that the complaint stated no cognizable legal theory. Well, the complaint has gotten past that initial hurdle now. We don't have answers yet to what are the parameters in this context of the fair use defense, but we are going to have those answers over the next year or so. So the courts are addressing these issues. And I would say, by the way, it's no different than that's happened with in the past with any new technology, whether if you go back to Betamax or streaming or the like. These issues have been raised with every new technology. And the courts are going to address them, and we're going to have answers very soon.
All right. No, absolutely. Fair enough. You know, what we're going to do, gentlemen, is take a quick commercial break here. We've got sort of two big blocks we want to discuss. One, of course, is climate change, disputes around that. And the next one, of course, after that, which is top of mind for a lot of people here in India right now, geopolitics and how, that is affecting disputes, commercial and otherwise. Stay tuned. Coming back.
Cyril Amarchand Mangaldas presents CNBC-TV18, The Thought League Season 3, A Glorious Decade, A Century of Service.
Welcome back. You're with us here on CNBC-TV18, The Thought League Season 3. We're in conversation with Mr. Cyril Shroff and John B. Quinn. Gentlemen, thanks very much for staying on. Let's move on. Let's talk about climate change. John, if I can come to you, how is the issue of climate change manifesting as a legal issue, and how are courts responding?
Well, we're seeing climate change up in many different substantive areas of disputes. Just for example, one, corporate governance, and this is particularly true in the EU, where you have seen groups of shareholders challenge boards of directors as to what their policy is with respect to climate change, what their policy is with respect to promotion of petroleum and other fuels. We've seen Shell, for example. There was a challenge to the board of directors about Shell's policies and contributions to climate change. So one area is clearly corporate governance. Another is disclosure, securities disclosure. In the United States, although this is now seemingly changed under the Trump administration, but the SEC had promulgated rules requiring companies to make disclosures concerning their climate change risk. We still see these types of claims being brought. Another area is greenwashing, where companies have tried to promote themselves as companies that are climate friendly. And there have been challenges to whether, in fact, their disclosures are accurate in that respect, or as to whether They're just engaged in greenwashing. I mean, these types of issues across the board, securities, corporate governance, greenwashing, fraud, real estate, pretty much all types of claims. We're seeing climate change and climate change issues arise in one way or another.
Mr. Shroff, climate change manifesting as legal issues, is that a first world problem, or are we seeing that here in India as well? What's the experience?
Very, very much. And I think there are some additional layers of meaning here as well. So whatever John said, I think I would kind of take that as adopted in India as well. But in addition, there are a couple of nuances here. So for example, the Supreme Court of India has held the right to protect yourself against a deteriorating environment as a fundamental right under Article 21, which is the right to life. And that has been a very novel interpretation which has been given by the Supreme Court. So there was this famous case of a rare bird, the great Indian bustard, where there was a litigation in relation to whether certain electric lines which could hurt the bird should be overground or underground. And that is where the Supreme Court had then in the same matter, the two judgments. The first one said that since we have a stakeholder model of governance, that the boards of directors have a duty towards various stakeholders, including the environment. So that the first time the right to a sort of a clean environment or a safe environment in all its meanings was given the status of a legal right, which was probably more a softer principle then. And in the second case, which is probably more recent, 2024, it's been elevated to a fundamental right. Now, I think we're sitting on the threshold of a floodgate of class action. So we have in our legal system the ability to bring class action suits, and I think we are one judgment away from these two dots being connected of class actions on the one hand and breaches of duty by boards or managements of the right, their duties in relation to the environment. The day that these two chemicals sort of mix, you will have an explosion of legal cases. So the ingredients are all there. I think the stage is set at some point of time when somebody lights the spark for a slew of class action in relation to environmental breaches. So actually, I think India has moved ahead. It's a far more sophisticated system already.
Let's move on to the last one, right? Geopolitics. John, if I can ask you to set the base, because this is global in nature. We are moving towards what is often described as a multilateral world. Everybody doing their own thing, and the set order for the last 50 years perhaps being disrupted now. Wars and long-running ones, Russia, Ukraine in focus. Give us an example of how geopolitics is kind of sort of leading to disputes, and what are you seeing?
Well, yes, whenever you have geopolitical disputes, international disputes, you have friction between countries. That definitely plays out in the legal sphere. I mean, Ukraine, Russia, kind of an obvious example. Russian businesses, and Russians being in the West, being attacked by governments, assets being seized, Russian oligarchs kind of being persona non grata, even having difficulty getting legal representation. So, I mean, that's kind of an obvious example. As you mentioned, we've been involved in cases representing Ukraine versus Russia, both investment treaty claims and actions in London to collect, brought by the debenture trustee of Russia against Ukraine and London to collect on debt, as well as a case that we're prosecuting in the European Court of Human Rights representing Ukraine versus Russia. So those are just some obvious examples at the country level, but there are more subtle things that are happening. Look, for example, about the growing importance of Singapore as a center for dispute resolution in Asia. Historically, in the past, Hong Kong has been viewed as the most important and premier venue for resolution of disputes in Asia, arbitrations. It's been an important, extremely important, the premier arbitration center in Asia. it still remains very important to this day. So, I mean, as the world changes and as you have these frictions and conflicts, I mentioned another, you look at China, you know, there used to be, there were many, I don't have a number off the top of my head, of Chinese public companies in the US. Now those numbers are going down. We saw the ride-hailing, the Chinese ride-hailing company leave the U.S. public markets and go back to Shanghai. You know, in the past, we represented Western companies in China. We have 3 offices in China. The focus of our practice was disputes relating to inbound investment in China. That has all but disappeared, as Western investment in China has all but disappeared. Now our practice is more representing Chinese companies around the world in issues that they have with regulators or investments gone bad, you know, outside China. So you see these disputes, geopolitical effects having consequences in the disputes world as well.
That was very interesting. Mr. Shroff, give us an example. In your experience, what have you seen? Geopolitics and disputes therein?
Yeah, so I call it geolegal risk, and which I would define as politics manifesting through the legal vector to cause harm or opportunity, and we're seeing that. So for just to give Indian examples of the kind of things which John mentioned, I mean, for example, Press Note 3, which is the Indian version of CFIUS, or we're seeing investor treaty arbitrations. We are seeing significant, from a dispute perspective, sanctions. The sanctions whether against Russia or Iran. This is a whole area of disputes which has underlying it geopolitical issues as well. So I think all of the above. We are probably not in the main conflict between US and China, so we get a little bit of a sideshow on it. But nonetheless, geopolitics continues to be very important. And with what's sort of currently emerging just now in our neighborhood, let's see where that goes.
And that brings us to the end of this episode of Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League, Season 3, where ideas become action and insights pave the way for the future. A big thank you to Mr. Shroff and John Quinn for joining us today and sharing perspectives that truly help us stay ahead of the curve. As Cyril Amarchand Mangaldas celebrates a decade of pioneering leadership, this season continues to bring you more thought-provoking conversations with those who shape the worlds of law, policy, business and finance, both in India and globally. Until next time, stay curious, stay informed.
Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League Season 3, A Glorious Decade, A Century of Service.